Thanks, guys. I'm on. Okay, cool. So, thank you guys for coming. This is an area that's really near and dear to my heart because I did work as a curator in the art world for a long time before I became a lawyer. And a lot of what I was doing was trying to help artists really think about not only what they created, but how then to protect the work that they made once it was out in the world, which I think for a lot of artists doesn't come as a natural inclination because you just assume that people have the kind of goodwill that you do when it comes to making and sharing art. And that just isn't always the case, not necessarily from a bad faith perspective, just because people sometimes don't understand what rights mean and they don't understand what the difference is between something being publicly available online versus in the public domain, meaning no longer under copyright. So we're going to talk about kind of what that framework looks like. And generally speaking, both, we'll talk about what copyright looks like for your work, but also how this new AI landscape may be impacting your ability to protect your work and how you also might use it as an additional revenue stream for your work if you haven't yet sort of considered that and integrated that into your workflow. So to start, these are all very basic slides, by the way. So the basic foundations of copyright are that copyright protects your expression of your idea. So if you're sitting around with your friends and you're like, I have this amazing concept that I want to capture at some point, and it's going to look like this, and it's going to feel like this, and it's going to be, reminiscent of that. That is a great idea. That is not necessarily, that idea cannot be protected. As soon as that idea is what we call fixed in a tangible medium, that's the legal language of what actually constitutes a copyrightable work, then it becomes protected by copyright the moment in which it's fixed. So as soon as you capture it with your camera, as soon as you draw a picture on a piece of paper, as soon as you type up a letter on the computer, it becomes fixed in a tangible medium and it becomes protectable by copyright. Once you have that copyright, you have exclusive rights to do a variety of things with that work. You have this bundle of rights, I like to call it, and it includes the right to copy and reproduce and distribute and display and perform and create derivative works. So for instance, if you've made a color photograph and somebody makes a black and white photograph of that same photograph, that's a derivative of your original photograph that you own the rights to. And derivative works can be a variety of things. If you create a photograph that tells a story and somebody maybe takes components of that photograph and turns it into a short story, there's a question there of whether and to what extent that constitutes a derivative work. So there's a whole universe of what could be derivative, but it's important to remember that you don't just own the initial work that you create, you also own versions of that work that are derived from that initial work. And the reason copyright exists is so that you have the ability to monetize and control what you make. Otherwise, you would not be incentivized to put your work out into the world. If anybody could just take your work and do whatever they wanted with it, how could you make a living? How could you ensure that your work is seeing the light of day? So it's an incredibly important framework. And it's one that a lot of artists know that they have access to, but don't necessarily know how to make the best use of it for their benefit. So one of the major, boring but super important components of you being a copyright holder is registering your work for copyright with the US Copyright Office. I know we talked about copyright automatically existing, and it does the moment that it's created. But until and unless you actually have a registration for that work, you cannot legally enforce that copyright. What that means is a registration essentially says to the world, I own this copyright. I can sue now on this copyright for copyright infringement or for potential copyright infringement, and I can claim something called statutory damages. So under the law, there are two frameworks for your damages calculations. There's something called statutory damages, which basically means there's a minimum to a maximum that you can get for each infringement. In the US, it's a very, very wide range for willful. It can go up to $150,000 for willful infringement for a single infringement, or down to $300 for a non-willful single infringement. And a court will evaluate the degree of infringement and how many infringements occurred. So, for instance, photographers who take many, many photos at once, and many photographers have hundreds, if not thousands, of photographs that they've taken, even of a single shoot, and you register those in bulk, and there are various bulk registration options, and somebody takes all those photographs, that is an infringement of each individual photograph. If your photographs are registered for copyright, you could potentially obtain statutory damages for each one of those infringements, which can be huge awards. If you don't have a registration, or if you register your copyright only after the infringement occurs, in order to bring your claim, you are only eligible for actual damages, which is something that you have to prove through expert testimony and a lot of paperwork and a lot of discovery into your books. And it's a much more complicated, much more expensive process. So statutory damages really provides this kind of cut-through framework for establishing a range that you can almost be guaranteed, if you win, to get as an award for infringement. So just to recap quickly, registration, you have to have a registered copyright to be able to sue, and that registration has to have been in place before the infringement to sue for statutory damages, which is why a lot of artists say, well, why can't I just file registration if and when I see that an infringement has occurred, which is it's a perfectly reasonable approach. I don't expect there to be an infringement. If an infringement happens, I'll then register for copyright. And the response is you then won't be eligible for statutory damages if they occurred prior to the registration. So registration generally, it's one of these, before we move on to AI enter the frame, I just want to emphasize the importance of this and how accessible it is for artists to register their copyright. It's a $60 application fee. It's a very simple framework. It's a very simple interface. You can, ask a friend if you don't feel comfortable using a computer to help you. And it is one of those investment tools that you reap benefits from sort of down the line. And it's something that the first thing that I say to anybody who's ever concerned about their work and protecting their work and ensuring that they can maintain protection of their work is registration. All right, so the concept of AI is very broad, as a lot of people are very, curious about, I think now. There are two major streams of thought that, as photographers and artists generally, you should be keeping in mind when it comes to AI. There is the generative tools that train on data sets. Some of those data sets may include visual content like photographs, which raises a lot of questions about consent and whether and to what extent you have the ability to enforce the use of works, what that means. Is that copyright infringement? Is that fair use? We'll get to that in much more detail. And then the other component is using AI tools yourself as a supplement to the work that you're making on the back end. So you have taken this photograph, you maybe upload it to Photoshop, which is an AI tool. It's not a generative AI tool, but it is an AI tool nevertheless. And you ask yourself, I'm enhancing the colors here, or I am filtering something in the background, I'm erasing something from the background. Are these AI tools that somehow impact the ownership of my art? And then taking it one step further in the generative AI space, if you're using any sort of AI tool to create a new work and not just supplement a new work or improve a new work, that may also have implications on your ownership that you have to keep in mind with respect to registration and also enforcement. So I want to address each of those separately. So first is the question of, you are somebody who uses AI, generative AI tools to create work. What does the law currently say about ownership over AI-generated content? So we talked about the fact that if you as an individual are clicking the camera and you have created the image in front of you, you own the copyright in that work, whether or not it's registered. What the Copyright Office has now put guidance out for is how you can take a work that has been created using a generative AI tool, whether that's eligible for registration and therefore protection. The Copyright Office currently requires, and US law requires, human authorship. That's the number one foundation, is the requirement of human authorship in order for there to be ownership of a work. So anything that's purely AI generated, the Copyright Office currently is saying that that is not something that can be registered and therefore not something that can be protected through the courts, essentially. So there's this question of what is purely AI generated, what is something that has human authorship. There's a lot of real gray area. If, for instance, you're using a Photoshop tool, which arguably is AI, but you can very much, show sort of the human authorship that goes into that tool versus putting in a textual prompt into a generative AI LLM and asking it to create some image that you have in your head but haven't actually captured. Those are two very different use cases. What the Copyright Office currently says is if you have included a textual prompt, even many textual prompts, even hundreds of textual prompts to create an image using an AI platform, that is not human generated insofar as it cannot be registered as a human authored work and cannot therefore be protected. So it's a really, it's in my sort of experience and opinion with the US Copyright Office, this is a very quick response to a very scary system that is changing the way artists are functioning. There is a high likelihood, I think, that the US Copyright Office may adjust its approach as these tools become more integrated into our daily working lives. But as it currently stands, if you are using one of these tools and inputting textual prompts for a visual creation, the Copyright Office will not register that. And it essentially considers that kind of work to be unprotectable or to have no author, which creates a lot of issues if you are using those kinds of prompts and creating works that you're then delivering to a client, or using those prompts and putting those works on your Instagram page or on your website and assuming that you have protection over those works. What the platforms currently say and what the Copyright Office currently says is no, actually, you don't have protection over those works because they are not human authored. Now, the Copyright Office has been a little bit, not inconsistent, but they have been establishing new rules and guidelines as this technology has developed. The more we learn about the technology, the more these rules have had to progress accordingly. And it is plausible, I think, that once we get a better sense of, again, how to integrate these into our day-to-day, there may be adjustments made to these protocols in the Copyright Office that would allow a registration of a certain type of work, even if it does have AI assistance in this way. But as of now, what the Copyright Office requires is a disclaimer, essentially, of all of the elements of the work that were AI generated as opposed to the elements that were human authored, which, as you know, is one of the most difficult things to extricate. It's really difficult to look at a photograph that you have improved using any kind of tool and pull apart what was yours initially versus what has been improved upon by that tool. So what the Copyright Office currently requires is some sort of tracking of the aspects of the work that were AI generated versus the aspects of the work that were human authored. That's a very difficult process for most artists to comply with. My advice in this sense is whatever your standard practice is as of now, continue doing that standard practice. Don't change your practice. We'll have questions at the end if that's okay. But I know that this is a topic that there's a lot of questions on. So that's just something to keep in mind when you are making works. If you click the trigger and you are the ones who are creating the work and you have something that is improved or emphasized on by an AI tool and you try to register that work, currently you do have to disclaim, you have to tell the Copyright Office which of the aspects of the work are AI generated or human generated in order to get registration, and the registration will be solely on the human authored aspects of that work. So there's a lot of moving parts in there, but that is the current state of the law. So, I mean, we kind of discussed this, but who holds the rights to an AI-assisted work? Again, the human contributor will own the rights to the aspects that were contributed by that human. Terms of service on these generative AI tools often grant the rights to the creator. So the terms of service do not typically hold the rights to the service, but the service does retain the right, oftentimes, to use that work and reintegrate it as a training tool back into its training data sets. There's a lot of complexity in the collaboration of AI versus human, and you do have to be conscious of which tools you're using, what the terms of service of those tools say, and how you're using those tools to create a final product. One thing that is sometimes helpful in this regard, and something that has been sort of percolating in our industry, is contracts often. If you are, for instance, delivering work to a commercial client, if you have a contract with that commercial client that says, you can use AI tools, but as between you and the commercial client, you can own the work, so that you can at least try and enforce your rights over that work, even if you don't have registrations over that work, or the components of the work that you have been able to register. That's a way that we've sometimes managed to create a framework of authorship, of ownership, that takes into account that sometimes it's a little tricky to determine where ownership actually lies with AI-assisted creations. So just to recap sort of that component, you have the creation of your work. As soon as you create your work, you want to try and register your work. Even if you have used AI tools to create that work, you can disclaim the elements of that work that were used and created using AI, and that helps you then protect your work moving forward. The protection component, so before we hit on fair use, I just want to say a word about the use of works in data sets. So one of the big questions right now in this space is, I'm an artist, I put my work out into the world, I have it available on my website, I have it available on Getty, I license it to a bunch of different people. What is stopping any sort of LLM, any big data company, from scraping that work, taking those images and putting it into a training data set to train one of their models? Well, currently the state of the law is it's up in the air. I'm actually working right now on a lawsuit where we are working on behalf of a publisher suing OpenAI for copyright infringement for that very thing. And these decisions are still coming out, and there's a lot indicating where it might go. But at present, we don't yet know exactly whether the use of works in training, if those works then generate outputs that are substantially similar, whether that is considered copyright infringement or not. As of now, though, it is vitally important for anybody who is working in this space and who has visual work to ensure that you are taking a look at what the terms of service are for any platform that you upload your works onto. So for instance, if you are using Getty, make sure that you are looking to see what kind of rights Getty has, whether they have the right to then take your work and license it to a third party for use in training data sets. It's very difficult to know for a fact right now whether and to what extent your works are being used, but if you can generate outputs in some of these systems to see works that are visually similar to the works that you have, it may be possible to infer that your works have been used in training data sets. But it's really important now, as you enter into new agreements with clients or whomever you're delivering content to make sure that you have in those agreements that you are not, if you are in fact interested in not having your works in these data sets, you can create contractual restrictions to ensure that your works aren't used in training data moving forward. And that's something that you would have in contract. So that's just something to keep in mind moving forward. One of the big questions right now that is that's basically at the heart of all of these lawsuits is this use, this taking of works that are on the internet and publicly available but still protected by copyright, and using them in training data sets, is this use something called fair use? So under the Copyright Act, you have that bundle of rights that we talked about. And one of the exceptions to that bundle of rights is somebody can use a relatively reasonable portion of your work for a purpose that is commentary or criticism or is transformative of that work to create something completely new. And if it is transformative enough, if it has created something so new that it has in fact created a whole new product or a whole new work that doesn't sort of supersede the market for the initial work, then it's something that's considered fair use. And there's been a lot of case law around how fair use is determined. But the big question that is pending in these lawsuits right now that have been brought by both artists and authors against these large language models is the act of taking this content that exists on the internet and putting it into these training data sets in order to train these models to be smart and to create output that mimics human creativity, is that use fair? So there have been some recent cases that have given us a little bit of a direction on how courts are looking at this. There was a decision recently, Bart's v. Anthropic, where the court determined that the taking and the creation of that training data is potentially transformative, but if there is output from those models that essentially replace the need for the original work, it might not actually be fair use. So there are factors that are considered in determining whether something is fair use. One of them is the work transformative? One of them is how much of the work is being taken. One of them is how much is the market being impacted by the taking of this work. So when courts have been considering the four factors of fair use, they've been holding thus far that fair use for training, if the acquisition of the work is lawful, could be considered transformative and could be considered fair use. But we are still very much in the heart of these cases, and we do not yet have we don't know yet how the courts are going to rule on this and how that's going to impact how people use training data moving forward.
In the chat.
Yeah.
Someone's asking if this pertains to the entire country or is this region specific?
So U.S. Copyright is a federal statute, which means that it applies equally across the entire country. Each state has different interpretations under the specific state law of fair use factors and copyright infringement, but by and large, we're talking about federal all across the United States. There's very little deviation when it comes to these kinds of cases. I will say that the cases that there have been decisions on were in California. There are a lot of cases pending in New York. California and New York tend to be the two jurisdictions that are most likely to hear these cases because they are the two jurisdictions that deal most heavily in creativity and productions and entertainment. But you can pretty much, if one court rules that this is fair use, it's very unlikely that another federal court rule that it is not on similar facts. So upcoming legislation, court decisions, what it could mean for you guys. So again, the US Copyright Office is constantly putting out AI-related registration guidance. I would not recommend you read it, as it is incredibly dense. But I will tell you that it is, if you are sort of creating a bulk registration mechanism for yourself, which you very, very well should, then you should keep in mind that if the Copyright Office sees in your application that you have disclaimed certain portions of your work because it was AI generated, that will impact your registration of the work. And it will also impact your ability to enforce your rights over that work as a whole. That's something to consider anytime that you use an AI tool to improve or create a new work from scratch. And it's important to keep in mind also that sometimes, again, improving a work is very different from creating a new work from a textual prompt. So as long as you are still maintaining the human authorship component of the visual creation, meaning you are behind the camera, you are setting up the scene, you are determining the aperture and the lighting, you are choosing which lens to use. All of those decisions lend themselves to human authorship and are really important for your registration. And as we move forward into this increasing landscape, there are going to be a lot of new definitions of authorship and derivative works and how that impacts how you can enforce your rights. And it's something that we're just going to have to continue to pay attention to. And unfortunately, because this is so new and this technology is so, it's sort of undermining and also increasing and emphasizing everything that we already know, we don't yet have sort of direct guidance on how we can apply it to our work, other than to say you have to pay attention to it. You have to start paying attention to things like terms of service that probably never really struck you as something that you should read. It's sort of, now is the time that if you want to really get the most out of your work, these are the things that you need to start paying attention to. Yeah, the takeaways, as I said, you know, AI is a phenomenal tool. You want to use it as much as you can if that helps with your work. You do not have to use it. I think there's this misconception that if you don't use AI, you're going to be left behind. I Don't know when that will become true or if it will become true, but for artists, I think it's really important to keep making your work and using AI only insofar as it increases or improves your creativity, but not as a replacement of your authorship if your goal is to really, enforce your rights and protect your work. Questions. I wanted to leave as much time as possible for questions because I know that this is a particularly question-oriented area. Yes.
If you input text and you're guiding it as to, I want it to be brighter, darker, I want it to be framed a certain way, I want the texture to be a certain thing, I want the clothing to look a certain way, certain style, and in other words, full input of your brain into that text, into that AI data training, transformative, blah, 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 fair use.
Yep.
What is the difference between that and pressing a button on a mechanical device that gathers light rays and you did not do anything other or different than capture or take a picture, take an image from an existing object in the universe that you did not create, have any touch, any feel for the database or anything else. It's so similar, it's not funny.
Yeah.
And the other question I might ask is,
well, let me just answer the first one just before I forget it, and I'll repeat it again.
Let's keep the questions pretty tight, though, guys. We have a live stream going at the same time, right?
So the question is, I'm just going to paraphrase it, and obviously you can correct me if I'm wrong, but the question is, isn't it as creative to input every aspect of a work into an LLM, every texture component, every formatting component, every lighting component, every composition component? Isn't that more or the same creativity as pressing a button that is potentially capturing whatever is just happening out in the world, even if you haven't created the scene that you're capturing? That's a fair. So I think the answer, and most of us could say that the fact that lawyers are determining what creativity is a real problem. Like the U.S. Copyright Office and the courts should not be determining the extent to which a particular creation is enough creativity to justify protection of that work. And that's been a concern of copyright lawyers for a long time, not just with respect to AI creations, but also with respect to fair use decisions, because a lot of the fair use decisions are a judge determining whether something is transformative enough as an artwork to make it not an infringing work. And that's a dangerous world to live in when that is the case. And it's something that a lot of lawyers are very conscientious of. And as a result, there's a lot of work to do, and a lot of work that people are doing to talk to the Copyright Office and try and influence the guidance in a way that that takes into account exactly what you're saying. How is it possible that if somebody is inputting 500 prompts or even a single prompt that is so detailed that it is creating a new product that they envisioned, and they are tweaking it, and you're sort of collaborating with the machine to create a final product? How is that not enough creativity to justify authorship? Whereas if I were walking down the street and picked up my camera and just, pressed a button and happened to capture whatever I happened to capture in front of me, that would be. It's a great question, and it's one that is not answered right now, I think, sufficiently by the guidance that we have in the Copyright Office. But it's one that I think will have to be addressed as this technology develops and as artists incorporate the technology more into their work.
and the follow-up to that is, how different is music sampling, which is taking another artist's work, making it transformative, and using data training sets in that field the same or different than doing it with AI, where again, you're the author, you're in control, you're the captain of the ship. How is it different?
Right. So the question is, how is music sampling different from what we were just describing? And the answer is fundamentally, it isn't. It isn't different. I think what we are talking about is a little bit of a fear of technology and a little bit of a fear of what could potentially happen if we don't step very gingerly into this new evolution of how these tools are going to integrate into the world. One of the most historic lawsuits that ever was a lawsuit about a photograph of Oscar Wilde, where Oscar Wilde was essentially, the question was, can this photograph, which is merely somebody pressing a button of a technology, of a new device, which happens to be a camera, could this photograph be copyrightable? Is this something that is capable of copyright protection because the language in the statute is so antiquated and it doesn't cover photographs? So how possibly could this photograph be protectable by copyright? And ultimately, the court decided, when the Copyright Act was being written, nobody knew how technology was going to evolve. Nobody intended for it to remain confined to only paintings or only drawings or portraits or things that were being created at the time before technology existed. And that was a really seminal lawsuit in this journey towards expanding the definition of what is art and what is copyrightable art, because that was before we knew that cameras existed. Now we know that it's obvious that anything that you take as a photograph, more or less, is copyrightable. We have no question that photography is art. So I think similarly, there are going to be, and I see a lot of similarities between the cases that we're currently litigating about whether, sort of these ownership questions of whether certain works can be considered authored by humans if they were created in the way that you described, with all of these prompts and with a very clear vision. It's also not dissimilar from how a director creates a film. I mean, they, have an idea in their mind and they direct different people and entities to bring that idea to life. And so I think there's going to be a lot of evolution on this topic, but I agree very much with the analogies that you're making. Yeah. Yes.
Can you comment on enforcement of copyright and use of AI? In the past, we had takedown notices, and now AI is being used almost preventatively to be embedded into video and maybe not necessarily in photography yet. But can you talk about that?
So the question was, can I talk about the use of AI and takedown notices? Are you specifically referring to DMCA takedown notices? And could you just give me an example of what kind of examples you are encountering?
Well, in the past, you reach out to, let's say, a distributor like YouTube and say, I didn't authorize this, you didn't license it for me, so you have on notice that you have to remove it from view.
Yep.
Or payment.
Yep.
Well, now AI is being used to be embedded into that video and say, well, if it's on an unapproved site, the image might be altered so it's unviewable. So those new tools are almost preventative, whereas the old model of takedown notices was detective, identify your enforcement.
Yeah. So the question is about DMCA, which I think a lot of people are probably familiar with in this room, but just as a quick recap, the DMCA is, or these takedown notices, is a protocol that websites have where if you identify some of your work that is infringed on YouTube or on any website, really, most websites have a DMCA takedown protocol. You can notify the website operator and they will take that work down. The next step of that process, though, is that whomever is notified, whoever put the infringing work up, is then notified that it was taken down because there was a claim of copyright infringement. And if they disagree that it's copyright infringement for whatever reason, they own the work, or they claim that they have a license, or they claim that it's not infringement at all because of the way that they're using it, they claim it's fair use, then they can notify the same copyright website operator, and the work can be put back up, or they have the option of suing to enforce the rights. So Unfortunately, any integration of AI tools into that kind of space will, at least in the beginning stages, probably make things a lot less efficient, because people are going to have to find a way to get to a human being to actually do what they have been asking that human being to do, which is either address the problem or refer the problem. And the DMCA has a lot of issues in and of itself, even before the integration of AI tools. But I would continue using DMCA takedown notices as a tool, as a mechanism. And it becomes this question of how and when do I enforce my rights? And if you are not getting a response, or, and the work is put back on, you might be in a position where you have to then enforce your rights. To that point, I do want to say that I know that it's tricky to enforce your rights when you're dealing with a single photograph, maybe, where it's going to be more expensive to consult with a lawyer for an hour than it would be to get what you are owed on that license. Maybe it's $500 or whatever it is, but that's real money. That's money that belongs to you. There's a small claims copyright court that actually does deal with sort of smaller damages claims that we can also talk about, just so you're aware. Yes.
Yeah, I actually wanted to talk about that because it happened to me twice. So one, Nipsey Hussle brother, he did an interview with Big Boy from radio station in LA, and they used one of my pictures that I took in 2019 of him. He don't have a lot of pictures out, so I know it was my picture. I went back to my Instagram, checked my Instagram, and checked my profile from when I edited on Lightroom, and it's the same picture because I could tell by the light. So I asked them, what's going on? Y'all using my picture? And they telling me we don't know what you're talking about. That has nothing to do with us. You have to contact Big Boy. I try to contact them and nobody answers me. And then another time I went viral for a video for two artists being together. A girl from TikTok took it, blew it up, and then Shade Room took it and blew it up. I didn't know, so they kept hitting me on Instagram telling me, oh, we got your video, can we use it? I'm like, no, take it down because it's mine. They like, well, technically we could use it because it's in the public and you put it up as public on YouTube. I said, but you didn't ask me, nobody said nothing to me, and I don't know. Now now the girl from TikTok got millions of views, and now Shade Room got millions of views. So I had to argue with like 3 different lawyers over the phone, and then they said, well, we'll give you $250 for your content, but we'll put it back up. We'll keep your name up there, but we'll still own the rights to the footage on Instagram. But on YouTube, you can have everything on YouTube. As far as Instagram, that's ours.
So the question, so this was, do you mind if I repeat the situation? So you're a photographer,
Yes.
right?
Yes.
So you're a photographer who's had his work taken from you and used in different ways in which you haven't
And I have no
authorized.
protection. I don't know what to do. I don't know
Right.
where to go to about it. And I feel like everybody made something off it except for me.
Yeah.
Yeah.
I mean, what you are talking about, so just for those who are listening, the question is, if your work is taken from Instagram, for instance, or from YouTube, and the response, if you bring it up to the person who took the work, is, oh, yes, but it's publicly available, and therefore I'm entitled to take it, that's wrong. That's not what the law says.
Yeah.
Just because a work is publicly available, which if you're an artist, hopefully your work is publicly available. That's how you get your work out into the world.
Yeah.
Keeping it in a drawer at home is not going to get you anywhere.
You guys got millions of views, and I'm still back at 200, 300 views.
So no, but it's a really frustrating reality, and I think it happens to a lot of artists where you don't. And I think it also happens with a lot of people who acquire work where they don't realize that just because something is publicly available on YouTube or on Instagram, that doesn't make it free for the taking. A situation like that is really tricky because if you haven't registered your work, for instance, then any savvy lawyer on the other side will say, well, you really don't have any recourse. You can't really do anything about this because you can't bring a lawsuit. All you can do is claim that we infringed on your work and try and negotiate some sort of settlement. And that does happen. And sometimes, especially in a case where somebody is unwilling to remove the work that you claim to be infringing, and then you register your work and they continue using the work, the infringement continues to occur even after the registration. You could still then be eligible for statutory damages after the fact. As soon as you kind of start communicating to people who have taken your work without your permission, that you're serious about enforcing your rights, that you are willing to negotiate a reasonable license agreement, that's a post hoc license agreement, or you will enforce your rights and potentially bring a claim against them, that might be something that you have to do in order to get people to listen to you. But I have found that in situations like that, especially in artist-to-artist situations, most people have some empathy and sympathy towards their fellow artist. And oftentimes, if you reach out and sort of explain your position and explain your rights, as it sounds like you did, it can lead to some sort of settlement agreement or license agreement or payment. And if that doesn't happen, then you might have to look into more serious ways of enforcing your copyright. But I understand that it's extremely frustrating and difficult.
It's very difficult just to see your work out there.
Yeah, absolutely. But to that point also, when you put your work online, use watermarking,
I did that. That's
Yeah.
how the thing.
Yeah.
You got a lot of questions online, so let's just take a few of
Oh,
those
sure.
really quick. They're asking if small edits or removal isn't transformative enough to share copyright with AI. Does Warhol versus Goldsmith come into play? Because we have a guy who listens to a lot of law podcasts, so he's a lawyer now.
So if small edits or removal isn't transformative enough to share copyright, I'm not sure I understand the question. So let me break it down according to what I do understand. So typically, transformative, in order for a derivative work to be considered transformative enough for it to be considered fair use and not infringing, the changes have to be quite significant. And I'm not just saying visual changes. So small edits or removal of a certain aspect of the work will typically not qualify as transformative. Transformative is this a completely different work than what it was when it was first created? Does it have a completely different message? Is it conveying something that wasn't conveyed by the original work? If somebody were to think of this work, would they find the original? It's almost like, is this more of is it more inspired by, or does it completely change the meaning of the original work? This is where it becomes a little bit tricky when courts are the ones determining the meaning of an original work versus a transformative work or potentially transformative work. But you need the difference needs to be very, very big. So for instance, in the data set cases, what courts have been finding thus far is that taking works as they are and turning them into a data set that can train an LLM, that can train a large language model, is what one judge has called quintessentially transformative, in that it has created a completely different product from what the original product was. The original product was a photograph, let's say, for the purpose of selling a commercial product. And now the new product is an LLM that is a completely different use case to that original use. So courts have found it to be a transformative tool. The question now, which still remains open, is whether the fact that that transformative tool can still create what essentially amount to copies when you use the right prompts, if that is an infringement on the output side. And hold on, there was one more question of does Goldstein, it was the question I was just looking at, does Warhol and Goldstein come into play? It does come into play. So Warhol and Goldstein was a case of, it's the biggest fair use case we've had over the past 5 years, a Supreme Court case, and it was a photograph that Goldsmith had taken of Warhol, that Goldsmith had taken of prints that Andy Warhol had taken and turned into a screen print. Thank you, still screen print. And visually, the pieces were quite similar. Of course, it was a Warhol piece, and it looked very Warhol-esque, and there were a lot of changes in the work, and it looked, different. But the judge ultimately determined that it was not transformative, because the underlying purpose of the work, which is to be a beautiful visual work to convey to the world, was the same, and because it was also sold commercially. So it does come into play with these new lawsuits.
I think you answered a couple of these. So someone's asking if a company trained their AI and sells it for $100 billion, and 100 of those photos that were theirs, do you have any claim to that value? I think you just said it's transformative, right?
Well, so it's a really, really good question, because right now the transformative analysis, and I'm sorry to get technical or boring on this, because I know it can be a little annoying, but the transformative analysis is on two sides of the AI training ecosystem. There's the input side, that the creation of the training data sets, which actually train the models. That is what courts have currently determined is transformative, although that remains still a litigated question. And then there's the output. So there's when you input, let's say, a prompt into ChatGPT or Stable Diffusion or really any of these tools, and and you say, I would like a mouse with big ears and a long nose, and it outputs something that looks like Mickey Mouse, then, not that this actually happened, this is just an example, then there is a potential there that is a substantially similar, so that is a copy of a copyrighted work that's coming out on the other side of the machine. So you've created the training data set. We've sort of, the courts are leaning towards the creation of the training data set being transformative use, but on the other side of the training data set, it's outputting certain things that could still potentially be infringing. So if, for instance, a company's value comes from its training data set or model, and let's say that means that it comes from its outputs, because it's not just the model, right? It's what the model can do. So let's say the company's value comes from the outputs of its model, and it sells $100 billion, and your photos are 100 of those $100 billion. First, it's quite complicated to determine whether and to what extent your photos are part of that training data set, but assuming you have, that's what these lawsuits are, essentially, where a lot of these lawsuits are saying our content comprises X amount of the training data set that made this tool excellent. This tool is excellent because the underlying work that trained this tool is excellent. You couldn't have as good of a tool if you hadn't trained on as good of products. So the claims that are currently pending are, we need to be paid for the work that you took and used to train your models. I mean, that's really that's the gist of these lawsuits right now.
One more online. So they're asking if you've altered. There's AI-based features in Photoshop and things we all use as photographers. So how should these sophisticated tools be addressed during registration for copyright?
Yeah, it's such an excellent question because this guidance of disclaiming what you've used, what is AI generated from your work, is so vague and so very government insofar as you're the one who's supposed to make the decision of how to disclaim your work. And the Copyright Office also, they put it on the register, the author's responsibility to determine what to include in the registration. So I think this is a call that you have to make as an artist independently. If you created something and uploaded it into Photoshop and you used sophisticated tools to amend it, adjust it, revise it, edit it, make it into the final product that you've envisioned, but you know that you created the image itself, the core of the image, the underlying image was your creation, then during registration, you could probably, in the disclaimer, say something like, refining tools in Photoshop as your disclaimed AI use, and you will probably still get most, if not the entire work registered for copyright.
You got a couple more in here if you want to keep going with them. It's up to you.
Yeah, sure.
All right.
There was another question. Yeah.
I read up a little bit on YouTube. So it said, if you put your work up on YouTube and it's used on Instagram, that's different. That's an infringement. But if someone's on YouTube, your ability to have it protected is strictly YouTube's license says you're giving us the right to put it on YouTube, nowhere else. So it limits that. So that leads me to this question. Can you register your YouTube channel as a collection? And my second question is, has the Supreme Court been involved yet on any level in making any decisions to help us out so that we know where we stand at that level as well?
So question one is, can you register your YouTube channel as a compilation? Question two is, where's the Supreme Court in all of this? So question one, there are a lot of different ways that you can use the registration system to register different types of works. Compilations are one of them. Collections are one of them. Websites are a little tricky with respect to registration. You can't register a website per se, nor can you register kind of a a channel per se, you do have to register. If your channel contains 50 videos, you can register all of those videos as a collective. But it wouldn't be necessarily limited to, nor would you necessarily want it to be limited to, only your YouTube channel, because you would own those videos regardless of where they were being published. So yes, it is, the short answer is there are mechanisms to register various different kinds of works in bulk at the Copyright Office, and one of them is registering bulk collections. And the second question is no. The Supreme Court has not yet weighed in on any of this. So the cases currently are pending in the district court level. After the district court level, they will almost certainly go to the Court of Appeals level. And after that, they will almost certainly go up to the Supreme Court. So we have some time before these cases are ultimately decided. And by ultimately decided, I mean really when we have a sort of a solid framework for how to approach this going forward from a legal perspective. I will say the Copyright Office it's a government agency, so they have a lot of persuasive impact, but they are not the be-all, end-all of copyright analysis. So their guidance on registration is but one data point of how different entities are thinking about this problem. There have been lawsuits, one in particular that stands out, of people who essentially tried to create a work using an AI tool, tried to register it with the Copyright Office. The Copyright Office has refused to register the work on the grounds that it was not human authored, and that person has now brought a lawsuit against the Copyright Office to make the determination that the work is in fact protectable. So it's a pending issue, and there are a lot of people who are trying to get to the bottom of it exactly because of these open questions that remain. But no, there has not been any definitive guidance on it just yet. Yep.
This is more of a broad question.
Mhm.
Is there like just one tip besides copywriting that you would encourage photographers, videographers to incorporate their work stream, whether it's in the pre-production or post-production? I guess, like, what are you shocked that's like still coming across your like desk on a daily, weekly basis?
Yeah, it's such a good question. So the question is, what is number one piece of advice for content creators? And what is sort of a shocking thing that we keep dealing with, that if content creators just did this one thing, then maybe they could be protected. So it's two things, really. The first is contracts. Enter into good, solid contracts. Create one template contract where your work is protected, where it's clear what the ownership status is, where your licensing is very narrow and explicit, and it includes all of the things that you are authorizing the whoever you're delivering your work to do. That if that includes some reference to AI training data and the fact that you don't want or do want that data to be included or not included in any data sets that are licensed out. Contracts right now are really the most important tool that a creator can have, because as between you and whomever you're delivering your content to, if you're a commercial creator, you are ultimately delivering to some end distributor or some commercial client. And the best way you can protect yourself is making sure that you are contractually protected. And then, of course, I always tell, and I know that I'm a broken record here, but I always tell my clients to, first and foremost, when they create works, especially if they create them in bulk, because there are cheaper registration options in bulk, register your work. Create a monthly system where you automatically register your work every month, or whatever the situation might be, whatever the frequency is of your creation. Make sure that you are the kind of creator who has a record, because people don't want to fuck with people who have good records. Like, if you have, I'm so sorry.
I thought you're such a nice lady. Let's go. Don't strike me, YouTube.
I mean, if you are the kind of person who registers your work and enforces your copyright, people aren't going to take your work, or they're going to be less inclined to take your work, because a lot of the risk analysis that somebody thinks about when they're They don't have a large licensing budget. They want to make a cool film. They have found this cool image on the internet. They don't really know who the owner is. They don't really know how much it's going to cost. And they're like, well, this guy's probably not going to sue me. That's a big consideration, right? This guy probably doesn't have his works registered. This guy probably isn't sophisticated enough. This guy's not going to sue me. But if you're the kind of creator who has a registration system, you're signaling to the world that you are sophisticated and that you will enforce your rights. And it's such an easy way of just establishing that little edge for yourself as a creator in the world. Otherwise, and because the economy, the digital economy right now sort of forces you to put your works out there and make them as accessible as possible, sometimes to your own detriment, you are in a position where you kind of have to just hope that people are going to treat your works with the respect that you treat your works. And that's really hard to rely on.
Should you, like we use copyright symbols, should we do that on our YouTube channels and wherever else? Make a statement that says you will be prosecuted. In other words, get tougher. And somewhere the message has to be in the front end and the back end of videos we do. So do it on your website, do it on YouTube, just put the language in there.
Yeah, the question is one of the ways to signal to the world that you are protecting your copyright by literally putting on your website or on your YouTube channel, this is protected by copyright? The answer is absolutely yes. It used to be a requirement for creators to put the copyright, once they registered, to have a copyright notice on works. That's no longer a requirement, but it's still good practice. So yes, I would recommend doing that. Yeah.
Of better usage, put something that actually definitively describes, like a watermark or something.
Yeah.
That shows the work is yours repetitively on each work that you would maybe put on YouTube or something like that. So if you, in other words, if you have at the end the logo of who you are at the beginning of the end, doesn't matter. If you have that repetitively on each work that you put out, doesn't it establish an ownership at that point?
So the question is, if you use watermarking consistently, does it establish ownership? Is that a way to signal to the world that you have ownership? So it certainly helps. I mean, it's definitely something that should be incorporated into your work, and any sort of consistent signaling to the world that you are the owner of your work is key. It does not, in and of itself, have any legal enforceability. So just because you have watermarked your work, it doesn't give you any more or less rights than if you hadn't watermarked your work. It just signals to the world that this is the person who owns the work. And what's more is, if you have your work registered and you are eligible for statutory damages, there are two regimes in that statutory damages framework. There's willful infringement and there's non-willful infringement. And if your work is watermarked and it's very clear that you own the work, and it's very clear that it's under copyright, and somebody has taken it and incorporated it into another project or taken it for another reason without your permission, there's an argument to be made that it's willful infringement, and that increases your potential award exponentially. So there are benefits to it, but unfortunately, nothing prevents people carte blanche from potentially taking your work. These are all methods to, almost like, if that happens, this is then what you can do about it. Yes.
That leads to the most important question.
Okay.
If you get into trouble with somebody stealing your work, and you go to court and do your licensing and registration and then end up in a lawsuit, what's the percentage of success and length of time? Is it going to be you're going to sue for 5 years, cost you $1 million, and you make $10, or you're going to make General Motors, get down on their knees and beg you to take $50 billion and leave me alone?
Yeah. So the question really is, is the juice worth the squeeze when it comes to filing a lawsuit? If you know you've been wronged and you're up against, typically these are big companies who have deep pockets, who maybe don't even realize that they are taking work that is unauthorized because they've gained access to it through some other way. The answer is very lawyerly. It really depends. But no lawsuit is quick and easy. It doesn't exist. Lawsuits are long and hard and arduous and exhausting and expensive. However, there are a lot of law firms who take on these kinds of mass copyright infringement claims on contingency because there are very high rewards that could be gained from a potential award. So, for instance, if you're a photographer who has hundreds of works that are registered for copyright, or thousands of works that are registered for copyright, and you see all of those works on some online marketplace that sells a lot of products, and your works are being used to sell those products, and you hadn't authorized that use, and you trace it back to a license that you had given to some third party who apparently breached that license and has now provided those images in an unauthorized way to a third party, you have a potentially very lucrative lawsuit on your hands. And it's a very case specific sort of analysis, but a lawyer could tell you this will yield a high settlement. And if you bring a lawsuit, it's very likely that the question of liability is obvious. The work has clearly been stolen and there was no authorization. And so the question just becomes one of damages. Most third parties, or most defendants in that case, will not want to go through the pain and suffering and the financial insanity of a lawsuit to get to a damages analysis. They will say, okay, we'll pay you this much. So a lot of times those lawsuits settle before they go to trial. A lawsuit that goes to trial is typically one where the question of liability is unclear. So maybe somebody claims that they did have a license, or that their use is within the scope of a license that that the author is claiming it isn't. When the question is liability, it's much more complicated. When the question is damages, the amount owed, it can settle long before it goes to trial.
This is my last question. So should we be scared to put out content, or just protect ourselves by protecting our content and still put out content?
You should definitely put out content. You're artists. You can't not put out content. It's like you breathe content, right? Like you create things, and you should. I mean, the copyright regime it exists to protect you. It exists to help you make content, to incentivize you to make content, to show the world all of the amazing things that people can make from their minds. It's something that, if anything, I really do think that this era of AI, it's a little bit of a blip in what's going to be a very long history of a lot more creativity and a lot more authorship generation. I really think that this moment that we're finding ourselves in, when people are kind of tiptoeing around what is human authorship, what is machine authored, that's going to, I think, my prediction is that that's going to change the more we see people using these tools to enhance their creativity.
So we should play into it.
I mean, if that's what your creative mind is leading you to do, then yeah, I think you should embrace, in the same way that, when cameras were being created, anybody who felt compelled to use a camera should have embraced using a camera as this new amazing creative tool. These are new amazing creative tools. And I think one of the issues that currently is kind of that people are questioning is, are they going to replace human authorship? And because there's this fear of replacing human authorship, the Copyright Office and other agencies are putting these rules down to ensure that they don't replace human authorship. That's why there are these strict guidance, that's why you can't register a work that's been created by an AI, because they are concerned that means that we're not going to be that people are not going to be incentivized to create. I think it's up to artists to show that that's not the case at all, that in fact these tools are only increasing the creation, that, that we're making even cooler things, that there's even more sort of out there in the world, that innovation is not dead, but it's actually, been reborn. That, I think, is the kind of thing that will change the guidance, because, one thing begets another.
Okay, thank you.
Yeah.
CapCut is a tool that many filmmakers use, and I read somewhere where they all of a sudden decided that if you use their tool, they have the ability to somewhat own your work, even if you had not uploaded. And a lot of companies like Photoshop tend to try to, after you use their tools, to somehow even access material that you haven't even,
Yeah, so the question is about different tools in their terms of use, and whether those tools own the material that you create using those tools. The companies, if the companies own the material that you upload into their systems. Sometimes it really depends on the company. There are certainly companies that their terms of service will very clearly say, if you use our service to record your story or whatever it is that you're doing, we will own the content and can do whatever we want with it. Or even if they say you will own the content, but we can still do whatever we want with it, that's also very common. In a lot of cases, because these companies are now also trying to use their repository of content to license it out to third parties and to these, AI companies and make extra money for themselves. They cannot do that if artists are not agreeing to their terms of service. If artists are agreeing to their terms of service, which essentially just means using their product, then yeah, some of them have very, very, tough language to get around. So I would recommend that you read the terms of service before you use a tool. For the most part, though, the generative AI LLMs do not own their terms of service. Do not state that they own the material. The output, that is, the output is transferred usually back to the owner or back to the author.
So online, there's just a bunch of questions basically asking about if something was taken in another country. So if you did something from the US and it's used in Canada, or just worldwide in general, how any of this applies, just like very broad stroke.
Yeah, so I can really only speak to this in broad strokes because I'm a US lawyer. But if your work is created in the US and then it's used abroad, it's difficult to enforce. You would have to find a way for it to have been used in the US. So it could be anything from, if a Canadian broadcaster broadcast a show out of the country, but you can access that on YouTube in the US, that could be enough to bring them into the US. So this day and age, it's actually a little easier to get international infringements into the US, but it is something that it does add some complications, yes.
You guys good? So if you guys want, you can watch this one back. I know it was a lot. She said a lot.
I'm sorry.
That's good. She's a lawyer, right? Listen, we want to thank Gili for being part of this. Give her a nice round of applause, guys. All right. Make sure you hit subscribe if you're watching this online, and we'll catch you guys on the next one. All right. Later, guys. Bye, Gili.
Thanks.